Power to stop proceedings. The administration of criminal justice requires that criminal proceedings should continue only when their continuation serves the interests of justice. In certain situations, it may become unnecessary, inexpedient, or unjust to continue a criminal case. To address such situations, the law confers upon the magistrate the power to stop proceedings in specified cases. The power to stop proceedings enables the court to terminate criminal proceedings at any stage without pronouncing a judgment on the merits of the case. This provision is intended to prevent the misuse of judicial process, save judicial time, and avoid unnecessary hardship to the accused where further continuation of the proceedings is not warranted. Legal provision. The provisions relating to the power to stop proceedings are contained in Section 281 of the BNSS 2023, which is corresponding to Section 258 of CRPC 1973. Section 281 empowers a judicial magistrate to stop proceedings in certain summons cases instituted otherwise than upon a complaint. Object of the provision. The main objectives of Section 281 of the BNSS 2023 are to prevent unnecessary continuation of criminal proceedings, to save valuable judicial time and resources, to protect the accused from prolonged litigation, to ensure that criminal proceedings are conducted only where justified, to enable the court to act in the interests of justice. Scope of the provision. The power under Section 281 applies only to summons cases instituted otherwise than upon a complaint. Thus, it generally applies to cases instituted on police reports or other forms of information not amounting to a private complaint. The provision does not apply to warrant cases or complaint cases. Essential features of the power to stop proceedings. Power available at any stage. The magistrate may stop proceedings at any stage of the trial before pronouncing judgment. This wide power allows the court to assess whether continuation of the proceedings is necessary based on the facts and circumstances of the case. Magistrate must record reasons. The power cannot be exercised arbitrarily. Section 281 specifically requires that the magistrate must record reasons for stopping the proceedings. This requirement ensures transparency and judicial accountability. The recorded reasons must demonstrate that the magistrate has applied his judicial mind to the facts of the case. Competent magistrates. The following magistrates may exercise this power: a judicial magistrate of the first class or any other judicial magistrate with the previous sanctions of the chief judicial magistrate. This restriction prevents indiscriminate use of the power. Effect of stoppage of proceedings. The legal consequences of stopping proceedings depend upon the stage at which the order is passed. Stoppage after recording evidence of principal witnesses, where the proceedings are stopped after the evidence of the principal witnesses has been recorded, the magistrate shall pronounce a judgment of acquittal. In such a case, the accused obtains the benefit of an acquittal and is protected against being tried again for the same offense, subject to the law relating to double jeopardy. Stoppage before recording evidence of principal witnesses. Where proceedings are stopped before the evidence of the principal witnesses has been recorded, the accused shall be released. Such release operates as a discharge and not as an acquittal. A discharge does not amount to a final determination of innocence and inappropriate circumstances, fresh proceedings may be initiated according to law. Difference between acquittal and discharge. The distinction between acquittal and discharge is significant. An acquittal results from a judicial determination that terminates the proceedings conclusively and generally bars a fresh trial for the same offense. A discharge, on the other hand, merely releases the accused from the proceedings at that stage and does not necessarily prevent future prosecution if legally permissible. Section 281 recognizes this distinction by linking the consequence to the stage of the proceedings. Judicial interpretation. State of Karnataka versus L. Muniswamy 1977 2 SCC 699. The Supreme Court emphasized that criminal courts possesses inherent responsibility to ensure that judicial process are not abused and that proceedings which do not serve the ends of justice should not be unnecessarily continued. Common Cause versus Union of India 1996 4 SCC 33. The Supreme Court highlighted the importance of avoiding undue delay in criminal proceedings and recognized the need for mechanisms that prevent unnecessary prolongation of trials. Importance or significance. The power to stop proceedings serves several important functions. It prevents abuse of the criminal justice system. It reduces unnecessary burden on courts. It protects accused persons from prolonged and unjustified litigation. It promotes speedy justice. It enables courts to focus on cases that genuinely require adjudication. The provision reflects the principle that criminal proceedings should not continue merely for the sake of formality when justice does not require their continuation. Conclusion. The power to stop proceedings under Section 281 of BNSS 2023 is an important judicial safeguard in summons cases instituted otherwise than upon a complaint. It enables the magistrate to terminate proceedings when their continuation is unnecessary or unjustified. Depending upon the stage of the case, such stoppage may result either in acquittal or discharge of the accused. The provisions promotes fairness, judicial economy, and the efficient administration of criminal justice.